The moment that changes everything. It's 11:47 p.m. You're driving home from work, exhausted, your mind already at your kitchen table with a cup of coffee. Red and blue lights flood your rearview mirror. Your heart does that thing it always does. You pull over. An officer approaches your window, and in that moment, everything you think you know about your legal obligations becomes irrelevant because you're about to face a decision that will either protect you or destroy you. Most people don't realize that the traffic stop is the most dangerous legal interaction an American citizen can have with law enforcement. Not physically dangerous, though that's sometimes true, legally dangerous. During a traffic stop, you have seconds to make decisions that will echo through courtrooms, affect your employment, impact your family, and potentially cost you thousands of dollars in legal fees. The terrifying part is this. Most people make those decisions based on fear, not facts. They make them based on what an officer tells them, not what the law actually requires. And by the time they realize they made a mistake, it's too late. Today, I'm going to give you something most people never get. A complete breakdown of every single interaction that happens during a traffic stop, exactly what you're legally required to do, exactly what you're not required to do, and the specific responses that protect your constitutional rights without creating additional legal problems for yourself. Section 1. Before the officer even approaches, the lights are on. You're pulling over. This is actually where your legal protection begins, not where it ends. You have decisions to make right now, and they matter tremendously. First, establish that this is a lawful stop. Not every traffic stop is legal. An officer cannot pull you over without reasonable suspicion that you've committed a traffic violation or a crime. But here's what most people don't understand. You'll have time to challenge whether the stop was lawful, but that time is not right now. Right now, at the roadside, is not the time to litigate the validity of the stop. That happens in court. Your job right now is to survive the stop safely and preserve your rights. So you're pulling over. Find a safe location. Turn off your engine. Keep your hands visible on the steering wheel. Crack your window down to about 4 inches. Do not open the door. Do not get out of the vehicle. The officer will approach. This is standard procedure, and it's actually in your favor because it establishes clear boundaries. You're not on the officer's turf. You're in your vehicle. That matters more than you think legally. As the officer approaches, you keep your hands on the wheel. The officer will ask for your license, registration, and proof of insurance. You are legally required to provide these documents. This is not optional. Failing to provide these documents is a separate crime, so provide them. But here's the critical part. You are not required to answer questions about where you're going, where you're coming from, or anything else beyond providing those documents. Section 2. The first questions. The officer will likely ask questions. Do you know why I stopped you? Or where are you headed? Or have you had anything to drink? These are consent-based questions designed to get you to volunteer information that can be used against you. Here's your exact response. Officer, I've provided my documentation. Am I free to leave or am I being detained? This question does something powerful. It forces the officer to declare the legal status of the stop. Either you're free to leave, which means the stop is over, or you're being detained, which means the officer must have reasonable suspicion of a crime. If the officer says you're free to leave, you leave. You say nothing else. You don't answer questions. You don't explain. You drive away calmly and safely. If the officer says you're being detained, that's when everything changes. A detention means the officer believes you may have committed a crime. A detention can last for a limited time, typically 15 to 30 minutes, while the officer investigates. During this time, you have rights, and those rights are specifically designed to protect you. The moment you're detained, you say this: I'm going to remain silent, and I want to speak with an attorney. Say it clearly. Say it audibly. Say it so there's no ambiguity. This is not optional phrasing. The Supreme Court has been extremely clear about this. If you simply stay silent without saying these words, your silence can be used against you in court as evidence of guilt. But if you explicitly invoke your right to remain silent and your right to an attorney, questioning must stop immediately. Any statements you make after invoking these rights are generally inadmissible in court. Section 3. The Field Sobriety Test Trap. If you're being detained and the officer suspects impaired driving, they will eventually ask you to perform field sobriety tests. This is where people make catastrophic mistakes. They think complying with a field sobriety test is legally required. It's not. Field sobriety tests are completely voluntary. Here's what most people don't understand. Field sobriety tests are not designed to determine whether you're impaired. They're designed to create evidence that you're impaired. A police officer administering a field sobriety test is not trying to help you prove you're sober. They're building a case against you. Every stumble, every sway, every moment of confusion is recorded and becomes evidence. When the officer asks you to perform a field sobriety test, your response is, "Officer, I respectfully decline to perform field sobriety tests. I'm invoking my right to remain silent, and I want an attorney." Don't argue about it. Don't explain why. Don't say you're sober so you'll pass. Just decline clearly and calmly. The officer will likely tell you that refusing makes you look guilty. That's an interrogation tactic. Refusing does not make you look guilty in the eyes of the law. Refusing is your right. Exercise it. Now, the officer may still arrest you on suspicion of driving under the influence based on other factors. If that happens, you're going to be taken to a police station or hospital for a breath or blood test. This is where you get a critical choice. Section 4. The breathalyzer decision. At the station, the officer will offer you a breathalyzer test. They will tell you that you're required to take it. In many states, this is true. There are implied consent laws. If you refuse a breathalyzer test, your license will be automatically suspended. This creates an impossible choice, and the system knows it. Here's the actual law. You have a right to refuse the breathalyzer test. You will face consequences for that refusal, specifically license suspension. But a refused breathalyzer test cannot be used as evidence of guilt in criminal court. However, a failed breathalyzer test absolutely can be used as evidence of guilt. So you're choosing between a civil consequence, license suspension, and a criminal consequence, a failed test that proves your impairment in court. This is a decision you should make in consultation with an attorney, not at the roadside. But if you're in the situation, understand what you're choosing. If you refuse, you face license suspension, but you don't have scientific evidence of impairment in court. If you take it and fail, your license is suspended anyway, but now there's also irrefutable evidence of impairment that will be devastating in criminal proceedings. Section 5. The search and seizure minefield. During any traffic stop, there's always a possibility the officer will ask to search your vehicle. This is where your Fourth Amendment rights come into play. An officer cannot search your vehicle without your consent or without a search warrant, except in very limited circumstances. When the officer asks to search your vehicle, your response is, "Officer, I do not consent to any search of my vehicle." Say it. Say it clearly. Do not consent. Do not explain. Do not negotiate. If the officer searches your vehicle anyway, you have grounds for a Fourth Amendment violation, which could result in evidence being suppressed in court. But if you consent to the search, you've waived your Fourth Amendment rights completely. You've given the officer permission to search anywhere in the vehicle, including the trunk, the glove box, under the seats, everything. Even if the officer insists that they'll search anyway, maintain your position. I do not consent to a search. If they search despite your objection, they're violating your rights, and that violation becomes evidence for your defense. But if you consent, you have no defense. Section 6. Recording and documentation. You have an absolute right to record police during a traffic stop if you're doing so from your own vehicle or from a public place. This has been confirmed by multiple federal courts. The officer cannot force you to stop recording. If the officer tells you to stop recording, your response is the same as before. Officer, recording police in public is protected by the First Amendment. I am not interfering with your duties. Recording serves multiple purposes. It documents what actually happens during the stop. It creates a record of everything said. It protects you legally because it eliminates the officer's ability to claim you said something you didn't say or did something you didn't do. If you don't have a phone handy, ask the officer if you can have a witness present. You have the right to request a witness to the stop. This isn't universally practiced, but it's your right. A witness creates another account of what happened. Section 7. What happens after the stop? If you're cited or arrested, you now have one critical responsibility: document everything. Write down the officer's name, badge number, date, time, location, and exactly what was said. Write down any injuries you sustained. Take photos of your vehicle if there's any damage. Get the names and contact information of any witnesses. Then immediately request an attorney. Do not answer any questions without an attorney present. Do not give a statement to the police. Do not explain your side of the story. These actions feel wrong because we're conditioned to want to explain ourselves, to make people understand our perspective. But in a legal context, anything you say can and will be used against you. Section 8, the real-world impact. Let me give you a real example. In 2019, a man in North Carolina was pulled over for a broken taillight. The officer asked him to perform a field sobriety test. He declined. The officer arrested him anyway. At the police station, he was offered a breathalyzer. He refused. His license was suspended, but he was also charged with DUI. At trial, the prosecution tried to use his refusal to take the breathalyzer as evidence of guilt. But because he had an attorney who understood the law, the court ruled that the refusal was inadmissible. Without the breathalyzer evidence, the prosecution couldn't prove impairment beyond a reasonable doubt. The case was dismissed. If that man had agreed to the breathalyzer and failed it, he would have had a DUI conviction on his record. Instead, by understanding his rights and exercising them, he walked away clean. Traffic stops are inevitable for most drivers. You will face them. The question is whether you'll face them informed or uninformed, whether you'll protect yourself or surrender your rights. Here's what you need to remember. An officer's authority is real, but it's not unlimited. The Constitution sets boundaries around that authority. Your job is to know those boundaries and assert them calmly, clearly, and without aggression. If you remember nothing else, remember this: am I free to leave? I want to remain silent. I want an attorney. I do not consent to any searches. Those 4 statements will protect you in 95% of traffic stop scenarios. The roadside is not the place to fight the law. It's the place to protect yourself so you can fight the law in court if necessary. Stay calm. Stay polite, assert your rights, and survive the stop legally intact. This is educational content about your legal rights. Always consult with a qualified attorney for your specific situation.